One missed detail in a Form I-485 case can lead to a denial, longer delays, and in some situations a move into removal proceedings. If you are preparing for a marriage-based adjustment of status interview, the next few minutes could help you avoid some common mistakes. I'm going to walk through the 5 denial reasons I see most often. Filing when you are not eligible, a denied I-130, inconsistent interview answers, inadmissibility problems, and the newer USCIS memo affecting certain offices. This is general information only, not legal advice for your specific case. First, many denials start with people filing Form I-485, even though they are not actually eligible to adjust status. That happens most often when someone entered the United States without inspection, or when they are filing under a family preference category instead of an immediate relative category. Preference categories include spouses of lawful permanent residents, children of lawful permanent residents, parents petitioning for adult sons or daughters, whether married or unmarried, and sibling petitions. There are other family categories too, so this is not a complete list. If you are out of status, overstayed a visa, or no longer have valid non-immigrant status, and you are trying to adjust through one of those preference categories, USCIS may not have the authority to approve the case unless the rest of the requirements are also met. In most situations, that means you need an approved I-130, a current priority date, and the other eligibility rules that apply to that category. A clear example of an immediate relative case is marriage to a U.S. citizen after lawful entry with inspection or parole. If you do not qualify and file anyway, a denial of the I-485 can put you at risk of removal proceedings, where you then have to defend the case before an immigration judge. Second, I see many adjustment cases denied because the underlying I-130 is denied. I have seen marriage-based cases where the interview was short and the officer asked only a few questions. In one example, the couple had filed some evidence, but not enough. They had an attorney, but the case file was still weak, and they were told everything would be fine. It was not fine. They did not receive a request for evidence asking for more documents, and they did not receive a notice of intent to deny, which would normally give you 30 days to add more evidence to the record. Instead, the case was denied outright. That is not the most common result in my experience because USCIS often does give applicants a chance to respond, but they are not required to do that. More and more, we are seeing officers deny the case without much warning. Once the I-130 is denied, the attached I-485, which is the green card application, usually follows within a month or two. After that, removal proceedings can come next. So now you have a case that might have been approved with stronger preparation, and instead you are spending more time and money defending yourself in immigration court. Without an approved I-130, that defense can become much more complicated. In some cases, the I-130 is the most important piece of the entire adjustment case, so you need a well-developed record before the interview, not after it. Another reason marriage-based adjustment cases get denied is when the I-130 interview goes badly because the spouses give inconsistent answers. This is especially common in offices where the officer separates the spouses and questions each person on their own for a long period of time, sometimes around 30 minutes or more. Some Massachusetts field offices, including Boston, do this, and Minneapolis does as well. That is usually their standard practice, not necessarily a sign that they suspect fraud from the start. When the interview is handled that way, it is very important to answer only what you know. If you do not know the answer, say you do not know. Do not guess, because the officer may ask your spouse the exact same question later. If the answers do not match enough times, USCIS can use those inconsistencies as support for a denial decision. In the written denial, they usually explain the problem very clearly. They will say Spouse A was asked one question and gave one answer. Spouse B was asked the same or a related question and gave a different answer. And when they were confronted with the inconsistency, they could not provide a believable explanation. After that, the officer may say the couple did not prove the marriage was entered into in good faith, and the I-130 is denied. In a worse case, the officer may go further and say the marriage appears fraudulent. A fraud finding is extremely serious and can create long-term problems for future immigration benefits. That is why you need to prepare carefully before any I-130 interview, especially if your local office is known for separating spouses. Another category of problems is inadmissibility, and the two issues that come to mind first are criminal inadmissibility and fraud-related inadmissibility. For example, let's say that 20 years ago you applied for some immigration benefit and you misrepresented a fact or left out important information, and USCIS denied that case. Years later, when you are filing a legitimate marriage-based adjustment of status application, that old misrepresentation can still come back and create a fraud issue. When that happens, USCIS often sends a request for evidence after the interview, saying you may be inadmissible because of the prior misrepresentation. They usually give you somewhere between 30 and 87 days to submit a waiver, often on Form I-601, to try to cure that ground of inadmissibility. To qualify for a fraud waiver, you generally need a spouse or parent who is a U.S. citizen or lawful permanent resident, and you have to show that the qualifying relative would suffer extreme hardship if you were removed from the United States. That is a simplified explanation, but that is the core of the requirement. Extreme hardship means more than the normal hardship any family faces when they are separated. Things like depression, anxiety, losing a second income, losing companionship, or a child being separated from a father or mother are real and serious. But in many cases, those consequences alone are not enough. Financial hardship can be part of the waiver case, but by itself, it usually will not meet the standard. The strongest waiver packages usually combine several different hardships and show the overall picture in detail. So if you have any prior issue on your record, speak with qualified counsel before the interview instead of waiting for USCIS to bring it up first. The final reason I am seeing adjustment of status denials is tied to a newer USCIS policy memo, which many people expect will be challenged in court and possibly rolled back or changed. In certain field offices, including Hartford, Connecticut, Fairfax, and at least one office in Florida, an officer reportedly told an attorney that they had instructions to deny some of these applications or hold them until headquarters sends more guidance. Most USCIS offices are not doing blanket denials under that memo. In my experience, many are simply putting the I-485 on hold for additional background checks, or that is what they say they are doing. We are not seeing a flood of approvals either, but we also are not seeing the same level of denials everywhere. Some New York offices are not even applying the memo the same way. In one recent interview at USCIS in 26 Federal Plaza in New York City, the officer did not ask about the new memo at all. The applicant had overstayed a visa and was married to a U.S. citizen, and the interview felt normal. They asked about the marriage and went through parts of the I-485. At the end, the officer said they would approve the I-130 and hold the I-485 for further background checks, then wished the applicants a good day. So in many offices, not much has changed, but you still need to be ready, because some offices are asking different questions. At a few offices, including San Bernardino, officers have been asking 4 specific questions. They may ask why you are filing for adjustment of status instead of using consular processing. They may ask whether anything is preventing you from doing consular processing. They may ask why you stayed in the United States after your visa expired. And they may ask whether you still have family in your home country. I am not completely sure why that last question is being asked in every case. It may be more relevant to people with asylum-related issues or people who are arguing that they cannot safely return. But whichever office you are in, the best approach is to have truthful answers ready ahead of time so you are not caught off guard. Do not walk in and say, there is no reason you cannot go back unless that is actually true. Prepare honest, clear responses before the interview. The main point is simple. Build the case carefully, prepare for the interview, and do not assume a weak file will be fixed later. If this video helped, please like, comment, and subscribe for more immigration updates.